Hi there. Thanks for joining me in this video. Today I'm going to be talking about the Fourth Amendment and searches and seizures. Now the Fourth Amendment, there's a vast amount of legal doctrine that goes along with it, and I can't cover all of it in this short video. So I'm going to try and give a very brief introduction and kind of a starting point for us to jump off of in future videos. But the Fourth Amendment in and of itself protects people and their effects from unreasonable searches and seizures. So a follow-up question to that becomes, well, what's unreasonable and what's reasonable? In looking at whether a search was reasonable or unreasonable under the Fourth Amendment, there are really two tests that we use. The first test is called the reasonable expectation of privacy test. And in that situation, what a court is looking for is whether or not the person had a reasonable expectation of privacy in the area that was searched, and whether that reasonable expectation of privacy is one that society as a whole would be willing to adopt. So, for example, you have to have a subjective reasonable expectation of privacy as well as a, objective reasonable expectation of privacy. A good example of this, and this is kind of a dated example, but a good example of this would be a payphone. And the Supreme Court case that actually gives us this doctrine comes from a set of facts similar to this. So say I'm in a payphone and the door is able to close and that space feels like a private space. So while I'm in there, I may subjectively have a sense and a reasonable expectation of privacy. And that expectation of privacy is one that most people would probably understand and agree with. Generally, society thinks that if you're inside of a payphone booth, you have a reasonable expectation of privacy there. So, if a police officer, without a warrant, is listening into that conversation, then that search would be unreasonable, and that evidence couldn't be used because it violates the Fourth Amendment. So the second test that courts use to determine whether or not something was a search and whether or not that was reasonable or unreasonable is they look at whether or not there was some kind of a trespass into your property. So there's a lot of exceptions, of course, to both of these rules, but in general, when the government is trespassing, that is unreasonable. And the best example I can give would be if a police officer just stormed into your house, they're trespassing inside your house. Now again, I want to reiterate that there are exceptions, and I'll get into those exceptions in other videos, but from the very, very basic standpoint, two tests. Whether you have a reasonable expectation of privacy and whether there's some kind of a trespass. Thank you for joining me. Again, this was a very brief overview of these two tests under the Fourth Amendment. I'll have more videos in the future addressing some more of these subtle issues, but if you have any questions, make sure you consult an attorney about whether or not some kind of a state action violated the Fourth Amendment. Thank you for joining me, and I'll see you next time.